International Copyright Law. Introductions to Copyright Law. Definitions, origins, and rationale of copyright. Key international conventions and treaties. When copyright arises. Exclusive rights granted by copyright. Term of copyright. Limitations and exceptions. Types of transfers. Enforcement and infringement of copyrights. International copyright treaties and conventions, and conclusions. International copyright law. A copyright law is a fundamental pillar of intellectual property rights, providing legal protections for original works of authorship. To understand the complexities of modern copyright legislation, we must delve into its historical roots, which can be traced back to the 50th and 60th centuries in Europe. During this period, governments sought to regulate and control the burgeoning printing industry, laying the groundwork for what would eventually become copyright law as we know it today. A pivotal movement in the evolutions of copyright law occurred in 1710 with the enactment of the British Statutes of Anne. This groundbreaking piece of legislation marked a significant shift in focus as it directly protected the rights of authors rather than merely regulating the printing industry. This statute is widely regarded as the progenitor of modern copyright law, establishing principles that would influence legal frameworks across the globe. Across the Atlantic, the United States enshrined the concept of copyright protections in 1787 constitutions. Article 1, Section 8, Clause 8 of the United States Constitutions, often referred to as the Copyright Clause, empowers Congress to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to the respective writings and discoveries. These constitutional provisions laid the foundations for the development of a robust copyright system in the United States. Copyright law stands as a cornerstone of intellectual property rights, offering legal safeguards for original works of the author. To fully appreciate these complexities, the roots goes back to 50th and 60th centuries in Europe. And also in 1710, the enactment of the British Statute of Anne, and the United States 1787 constitutions, which provides for the Copyright Clause. As society has evolved, so too has the scope of copyright law. From its initial focus on literary works, copyright protection has expanded to encompass a diverse array of creative works, including maps, charts, musical compositions, dramatic works, photographs, paintings, computer programs, and architectural designs, among others. The key principle underlying copyright is the protections of the original expression of ideas rather than the ideas themselves. This distinction is vital as it allows for the free flow of ideas while still providing creators with the necessary legal protections for the unique expressions of those ideas. Definitions, origins, and rationale of copyright. In many European countries, copyright legislation dates back to the 50th and 60th centuries, initiated by governmental efforts to regulate and control printing. The first act to directly protect authors' rights was the British Statute of Anne in 1710. In the United States, copyright is embedded in the 1787 constitutions. In Asia and Africa, copyright laws are more recent, introduced primarily by European colonial powers, notably the French and British. In Australia, copyright is governed by the Copyright Act 1968. Internationally, copyright issues are managed through a complex network of treaties and conventions, often overlapping and combined with national laws. There is no single international copyright law. However, with globalizations and the ease of cross-border disseminations of works, copyright laws are increasingly unified through international agreements. The World Intellectual Property Organization's WIPO defines the purpose of copyright law as fostering dynamic culture while ensuring creators can sustain a dignified economic existence and providing the public with affordable access to content. Copyright protects the original expression of ideas, not the ideas themselves. Ownership of a work differs from ownership of its copyright. Copyright is an intangible property, a choice in actions, so to speak. For instance, purchasing a book grants ownership of the physical book, but not the underlying copyright. Only the copyright holder can publish, reproduce, or copy the work. The Berne Conventions for the Protections of Literary and Artistic Works, 1886. It is a foundational treaty in international copyright law administered by the World Intellectual Property Organizations, WIPO. The conventions requires member states to comply with minimum standards for the protections of the rights of authors in their literary and artistic works. The Berne Conventions establishes a number of key principles, which includes national treatment. Member states must treat foreign authors' works in the same way as they treat works by their own nationals. Automatic protections. Copyright protections is automatically granted to works without the need for registrations or other formalities. Minimum standards. Member states must provide a minimum level of protections for authors' rights, including the right to reproduce, adapt, translate, and publicly perform their works. The European Union has several key directives to harmonize copyright laws. These include the Copyright Duration Directive, Resale Rights Directive, Database Protection Directive, E-commerce Directive, and the Enforcement of IP Rights Directive. The TRIPS Agreement on Trade-Related Aspects of Intellectual Property Rights. The TRIPS Agreement was promulgated in 1994 as part of the agreement establishing the World Trade Organization's WTO. It was a response to growing tensions in international economic relations regarding counterfeit goods in international trade. The TRIPS Agreement sets out minimum standards for the protections of intellectual property rights, including copyright, trademarks, patents, and industrial designs. The agreement aims to ensure that intellectual property rights are adequately protected and enforced in all WTO member countries, promoting fair trade and preventing the exploitations of intellectual property. TRIPS, established in 1994, addresses this specific growing international economic tensions related to counterfeit goods. TRIPS build upon and complements existing intellectual property conventions, including the Berne Conventions. The key aspects of the TRIPS agreement include: first, minimum standards. TRIPS sets minimum standards for various forms of intellectual property regulations, including copyright, that WTO member countries must implement in their national laws. Secondly is enforcement measures. The agreement requires member states to provide effective enforcement procedures for intellectual property rights, including border measures to prevent the importations of counterfeit goods. Another one is dispute resolutions. TRIPS brings international intellectual property disputes under the WTO's dispute resolution system, providing a mechanisms for countries to resolve conflicts related to intellectual property rights. Transitional arrangements. The agreement includes provisions for transitional periods allowing developing countries more time to implement the required changes to the intellectual property system. Technology transfer. TRIPS includes provisions aimed at promoting technology transfer to least developed countries, recognizing the importance of access to technology for economic development. TRIPS agreement has had a significant impact on the global intellectual property landscape, leading to more harmonized and robust protections for copyrighted works across WTO member states. The Anti-Counterfeiting Trade Agreement, ACTA, is a plurilateral agreement that was negotiated starting in June 2008. It involves the European Union, the United States, Japan, and other countries, including Australia. The scope of agreement is broad, covering counterfeit goods as well as piracy of copyrighted works. ACTA aims to strengthen international cooperations in combating counterfeiting and piracy, including through improved border controls, criminal penalties, and enhanced law enforcement measures. The key provisions of ACTA include civil enforcement. The agreement provides for enhanced civil enforcement measures, including the ability to order alleged infringers to provide information on the origin and distribution networks of infringing goods. Border measures. ACTA includes provisions for strengthened border enforcement, allowing customs authorities to seize suspected counterfeit goods. Criminal enforcement. The agreement requires signatories to provide for criminal procedures and penalties in cases of willful trademark counterfeiting or copyright piracy on a commercial scale. Digital environment. ACTA includes provisions specifically addressing copyright infringements in the digital environment, including measures against the circumventions of technological protection measures. International cooperations. The agreement promotes cooperations among law enforcement authorities in different countries to combat cross-border trade in counterfeit and pirated goods. However, it is important to note that this ACTA has been controversial. Critics argue that it could infringe on civil liberties and restrict access to generic medicines. As a result, the agreement has not been widely ratified, with the European Parliament rejecting it in 2012. As society evolves, so too has the scope of copyright law. From just literary works, copyright protections now encompasses a diverse array of creative works. Historically, copyright covers only books. Today, things such as maps, charts, prints, musical composition, dramatic works, photographs, paintings, drawings, sculptures, motion pictures, computer programs, databases, choreography, and architectural works are also covered. Copyright protection is automatic upon creations. The Berne Conventions prohibits registrations formalities for its members. In US, registration is not required for copyright to exist, but is necessary for enforcement. Copyright law grants authors a bundle of exclusive rights over their works, allowing them to control how their works are used and exploited. These rights include reproduction right, the right to make copies of the work, including in digital formats, adaptation rights, the right to create derivative works based on the original works, such as translations, adaptations, and arrangements, distribution right, the right to control the distribution of copies of the work to the public performance right, the right to perform the work publicly, such as in concerts, plays, or film screenings, public display right, the right to display the work publicly, such as in exhibitions or online, moral rights. In many jurisdictions, authors also have moral rights, which are non-economic rights that protect the author's personal connections to their work. These rights include the right of attributions, the right to be identified as the author of the work, and the right of integrity, the right to prevent distortions, mutilations, or other modifications of the work that would prejudice the author's honor or reputations. The Berne Conventions grant copyright holders exclusive rights to reproduce, to perform publicly, broadcast, adapt, alter, and translate their works. Exceptions include fair use for other publications and broadcasts. European directives address multimedia-related copyright issues, harmonizing online service provider requirements, transparency, commercial communications, electronic contracts, and intermediary service provider liability. The Directive on the Legal Protections of Databases provides sui generis protections for databases based on significant investment rather than originality. Droit de suite. The Berne Conventions introduced the concept of droit de suite, granting artists resale rights, entitling them to a fraction of the price each time their work is resold. In Europe, this is also covered by the Directive on Resale Right for the benefit of the author of an original work of art. The Berne Convention Minimum Standards. The Berne Convention sets the following minimum standards for copyright durations. As a general rule, copyright protections must last for at least the life of the author, plus 50 years after their death. Anonymous and pseudonymous works, for works published anonymously or under a pseudonym, in term of protections is at least 50 years from the date of publications. Cinematographic works, the minimum term of protections is 50 years after the work has been made available to the public, or if not made available, 50 years after the making of the work. Applied art and photographic works. For this type of works, the minimum terms of protection is 25 years from the making of the work. The rule of shorter term allows member states to limit the durations of copyright protections for foreign works to the term granted in the work's country of origin. In Europe, the Copyright Durations Directive ensures a single duration of 70 years from the author's death. The Butterfly case confirmed that expired copyright could be revived under new legislations. Extended terms in various jurisdictions. Many countries have chosen to implement a much longer terms of copyright protections than the minimum standards set by the Berne Conventions. For example, European Union. In the EU, the general terms of copyright protection is the life of the author plus 70 years. This extended terms was established by the Copyright Term Directive number 93/98 EEC, which later replaced by Directive 2006. In the United States, the Copyright Term Extension Act of 1998, also known as the Sonny Bono Act, extended copyright terms in the US to life plus 70 years for works created on or after 1st January 1978. For works made for hire and anonymous or pseudonymous works, the term is 95 years from first publications or 120 years from creation, whichever is shorter. In Australia, Australia-United States Free Trade Agreement Implement Act 2004 extended the general terms of copyright protections to life plus 70 years, aligning it with the US and EU terms. Limitations and exceptions often seen as the user's rights. It balances copyright's exclusive rights with public interests. The Berne Conventions allows them in special cases, leaving detailed legislation to signatories. A work enters the public domain when its intellectual property rights expire or forfeited or never claimed, making it publicly available without requiring authorizations. The 1928 revisions of the Berne Conventions introduced moral rights protecting works from alterations even after copyright assignment. In some jurisdictions, moral rights can be waived, but in Europe, exceptions are generally not possible. The First Sale Doctrine, recognized by the United States Supreme Court in 1908, allows the transfer of a copyrighted work's lawful copy without permissions. This doctrine, known as exhaustion of rights in other countries, also applies to patents and trademarks. However, copyright law also recognizes certain limitations on these exclusive rights, balancing the interests of creators with the public interest in accessing and building upon creative works. These limitations include such as fair use or fair dealing. This doctrine allows for the use of copyrighted works for certain purposes, such as criticisms, comment, news reporting, teaching, scholarship, and research, without the permissions of the copyright holder. The specific criteria for fair use, fair dealing vary between jurisdictions, but generally involve factors such as the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect of the use on the potential market for the copyrighted work. Exceptions for educational use. Copyright law often includes exceptions for educational use, allowing for the use of these works in educational settings, such as in the classrooms or libraries. These exceptions typically require that the use be non-commercials and that the copyright holder be acknowledged. Exceptions for libraries and archives. Libraries and archives are often granted exceptions to copyright law, allowing them to make copies of copyrighted works for preservation, research, and other purposes. These exceptions typically require that the use be non-commercials and that the copyright holder be acknowledged. The fair use in United States copyright law permits limited use of copyrighted work without permissions for purposes such as research, teaching, and news reporting, subject to a balancing test. The Berne Convention grants exceptions for quotations, teaching, illustrations, and news reporting, fair dealing in United Kingdom and other common law jurisdictions include similar principles and additional concepts like incidental inclusions and time shifting. Copyright owners can transfer their rights through assignment or licensing. Assignments are irrevocable transfers, while licenses retain ownerships but grant usage rights. Licensing agreements can be exclusive or non-exclusive and are governed by competition laws to prevent unfair practices. Collective rights management organizations, such as collecting societies, can negotiate extended collective licensing agreements for mass use. Copyright infringement occurs when someone uses a copyrighted work without the permissions of the copyright holder. Infringement can take many forms, which include reproductions, making unauthorized copies of the work, distributions, distributing unauthorized copies of the work, public performance, performing the work publicly without permissions, public display, displaying the work publicly without permissions, adaptations, creating derivative works based on the original work without permissions. Copyright holders can pursue legal remedies against infringers, including injunctions, the court orders that prohibit the infringer from continuing to infringe the copyright, damages, monetary compensations for the copyright holder's losses, criminal penalties. In some cases, copyright infringement can be a criminal offense, particularly in cases of large-scale commercial piracy. As a Berne Convention signatory, some states recognize the copyright works from other signatory countries. Copyright violations involve unauthorized use of protected works and are enforced through civil courts with criminal penalties for serious infringements. The European Directive on the Enforcement of Intellectual Property Rights harmonizes procedural rules and remedies for copyright enforcement. TRIPS standards, mandatory for WTO members, integrate intellectual property dispute resolutions into the WTO system. Directive on the Enforcement of Intellectual Property Rights, 2004, by European Council. This directive, adopted in 2004, aims to harmonize the enforcement of intellectual property rights across EU member states. Some of the key aspects include evidence. The directive provides measures for preserving evidence in intellectual property infringement cases. Right of information. It establishes a right of information, allowing right holders to obtain information on the origin and distribution networks of infringing goods. Provisional and precautionary measures. The directive provides for provisional measures to prevent imminent infringements or to forbid the continuations of alleged infringements. Corrective measures. It includes provisions for corrective measures such as the recall or destructions of infringing goods. And finally, damages. The directive sets out principles for calculating damages in infringement cases. Universal Copyright Conventions, UCC. It was adopted in 1952 and revised in 1971. The Universal Copyright Convention was developed as an alternative to the Berne Conventions, particularly for countries that found some of the Berne Convention's provisions too demanding. Key features of the UCC include copyright notice. Works protected under UCC must bear the C symbol. followed by the name of the copyright proprietor and the year of first publications. Minimum terms of protections. The UCC provides a minimum term of protections of 25 years after the author's death or 25 years after publications for certain categories of works. National treatment. Like the Berne Conventions, the UCC requires member states to provide the same protections to works by foreign authors as they do to works by their own nationals. While the UCC has been largely superseded by the Berne Conventions and TRIPS Agreement, it remains in force and continues to govern copyright relations between some countries. WIPO Copyright Treaty. Adopted in 1996, the WIPO Copyright Treaty is a special agreement under the Berne Conventions that deals with the protection of works and the rights of their authors in the digital environment. The key provisions include computer programs. The WCT clarifies that computer programs are protected as literary works under the Berne Conventions. Databases. The treaty provides copyright protections for databases that constitute intellectual creations. Right of distributions. Authors of literary and artistic works have the exclusive right to authorize the making available to the public of the original and copies of their works through sale or other transfer of ownership. Right of communications to the public. The treaty grants authors the exclusive right to authorize any communications to the public of their works by wire or wireless means, including making their works available to the public in a way that allows access from a place and at a time individually chosen by the members of the public. Technological measures. The WCT requires contracting parties to provide adequate legal protections and effective legal remedies against the circumventions of technological measures used by authors in connection with the exercise of their rights. WIPO Performances and Phonograms Treaty, WPPT. It was adopted alongside the WCT in 1996. The WPPT deals with the rights of two kinds of beneficiaries: performers such as actors, singers, musicians, etc., and producers of phonograms. The key provisions include moral rights. The treaty grants performers moral rights, including the right to be identified as the performer, and to object to any distortions or modifications of their performances. Economic rights. Performers and producers of phonograms are granted various economic rights, including the rights of reproductions, distributions, rental, and making available to the public. Right of communications to the public. The WPPT grants performers and producers of phonograms the exclusive right to authorize the making available to the public of the performances fixed in phonograms and phonograms respectively. Technological measures. The same like WCT, the WPPT requires contracting parties to provide adequate legal protection against the circumventions of technological measures used by performers or producers of phonograms in connections with the exercise of their rights. These international treaties and conventions form a complex web of obligations and rights that shape the global copyright landscape, providing a framework for the protections of creative works across national borders.